Breaking down yesterday's court order, which denied the government's request to unseal grand jury transcripts, this order is actually really interesting, so I thought we could talk about some of the parts of it. So the court goes through some background related to the proceedings against Ms. Maxwell, and then on page 6, we begin with DOJ's recent statements regarding the disclosure of Epstein records, and the court addresses some things that were said in various memoranda issued by the Trump administration and excerpts those for us here. Now, I think the most interesting thing is that after the government filed this 3.5-page motion to unseal the grand jury transcripts, the court actually required the government to go back and highlight portions of the grand jury transcripts that were not already part of the public domain and part of public knowledge, okay? So that's important to keep in mind here. As a side note, for my non-lawyers out there, this is federal court. Federal court is mostly decided on the papers, which means that you don't get a hearing. So if you want to say anything at all, you better say it in the motion or the response or the reply or whatever it is that you're filing with the court, because you might not get an opportunity to be in front of a judge. So the idea that this motion filed by the government is 3.5 pages really strikes me as short and not very robust. Most of the time, federal court filings have to have a memorandum of law, which is at least a couple paragraphs or pages, depending on the issue in the motion. But I think that the 3.5 pages strikes me as very short. The court then moves into the actual application of the law. Now here, this issue is decided by Federal Rule of Criminal Procedure 6E, and we've talked about it before, but that rule sets forth the instances when a court can order disclosure of grand jury transcripts. There are very specific reasons, none of which is relevant here. Now, when this issue was decided by a court in the Southern District of Florida, the Southern District of Florida said, if it's not one of these exceptions, we've got no discretion to unseal these records. We are stuck. We are limited by 11th Circuit precedent, which says if it's not an enumerated exception, there is no more that can be done. There's no room to unseal these records. However, this case related to Ms. Maxwell is actually in the Second Circuit, and the Second Circuit takes a different approach. The Second Circuit recognizes those exceptions, but also says that under certain special circumstances, there may be reasons to unseal the grand jury transcripts beyond just those enumerated in Federal Rule of Criminal Procedure 6E. So the Second Circuit has actually issued a set of what it calls non-exhaustive factors to consider to decide whether there are these special circumstances. They are the identity of the party seeking disclosure, whether the defendant to the grand jury proceeding or the government opposes the disclosure, why disclosure is being sought in the particular case, what specific information is being sought for disclosure, how long ago the grand jury proceedings took place, the current status of the principals of the grand jury proceedings and that of their families, the extent to which the desired material either permissibly or impermissibly has been previously made public, whether witnesses to the grand jury proceedings who might be affected by disclosure are still alive, and the additional need for maintaining secrecy in the particular case in question. So that is the universe of factors, non-exhaustive, that the court is looking at here to decide whether to unseal these grand jury transcripts. The court goes through some high-level description of the actual grand jury proceedings without going into too much detail, because the court doesn't want to give away everything that's in the transcripts. But it's important to note that there were 2 grand juries commissioned against Ms. Maxwell, and each grand jury received evidence on a single day and only by one witness, a law enforcement agent. There were no victims giving testimony. There was nothing but a law enforcement agent answering questions that were posed by an assistant U.S. attorney. And just to provide a little further context around these grand jury proceedings, the first grand jury met on June 29th, 2020, and it heard testimony for 1 hour and 25 minutes. The second grand jury met almost a year later on March 29th, 2021, and heard testimony for about 1 hour and 48 minutes. The second transcript is 117 pages, double-spaced, and the first transcript is 74 pages, double-spaced. We are not talking about a lot of material, you guys, just to give some non-lawyers context to this. That is very underwhelming from a lawyer's perspective. The court says, look, this evidence that was put before the Maxwell grand juries is today, with only very minor exceptions, a matter of public record, okay? And so there really is nothing here. The court notes, a member of the public familiar with the Maxwell trial record who reviewed the grand jury materials that the government proposes to unseal would thus learn next to nothing new. The materials do not identify any person other than Epstein and Maxwell as having had sexual contact with a minor. They do not discuss or identify any client of Epstein's or Maxwell's. They do not reveal any heretofore unknown means or methods of Epstein's or Maxwell's crimes. They do not reveal new venues at which their crimes occurred. They do not reveal new sources of their wealth. They do not explore the circumstances of Epstein's death. They do not reveal the path of the government's investigation. Now, I mentioned previously that the court actually considered the fact that there was nothing here as one of the special circumstances that could warrant the unsealing of the transcripts, to basically show the American public that there is nothing here. Now, the court ultimately denied that rationale and refused to find that that was enough here, but the court actually spends a little bit of time considering whether that could be the special circumstance present here. The court goes through each of those factors in turn to ultimately arrive at the conclusion that the government failed to satisfy its burden of demonstrating that the transcripts should be unsealed. And that is where we're at today with the Southern District of New York. So now we have the Southern District of Florida has clocked in denying a request to unseal the grand jury transcripts from the Epstein proceeding in Florida. Now we have the Southern District of New York denying the request to unseal the grand jury transcripts from Miss Maxwell's proceedings. We have one more remaining in the Southern District of New York with respect to grand jury transcripts in the Epstein case that was pending in New York. I suspect that that judge will come out the same way.